Well, welcome to Law Talks here on 4CRB, and today we are speaking to Attwood Marshall Lawyers Martin Mallon. Thanks for joining us, Martin.
Thanks, Steve. Thanks for having me.
So our topic for today is estrangement and disinheriting children, which I don't think we've talked about before. So, Martin, let's start with just in general. We know that it's common that parents and children can often not sort out their issues, and unfortunately relationships can break down, which cause estrangement. How often are you seeing these types of situations?
So, Steve, you're quite right. There are some polls that show that 45% of Australians don't have a will. For me personally, I find that quite alarming, because that means that if you pass away without a will, then potentially some of your estate could be left to your estranged child or parent, which you may not have wanted if you did have a will. So firstly, the recommendation is to get a will, to speak with a lawyer who practices in estate planning that can sit down with you to draft a will in accordance with your wishes. If you leave it later on in life, sometimes you run into issues with capacity, because you need to have capacity to sign a will and to sign an enduring power of attorney. There are also some issues and just simply leaving out an estranged child, because if you see someone who can draft your will and provide you advice, they can mitigate these issues and provide you with options as to how to minimise potential claims.
Do you get situations where someone has left someone out of a will, but then there's been some reconciliation, so they've got to remember, I've got to go back and change my will, and they forget that they may have left someone out of a will?
100%. We find that, we recommend that people revisit their will every year, so that things can change. You may fall out with the executor, fall out with children, and you don't perhaps need to change the will, but just to have that as a remembrance to go back and to see, do I need to change my will? Do I need to update it? If you don't, then that's fine, but just to have that in the back of your mind.
Yeah, because that could be a very unfortunate thing, is that you've left someone out of a will years ago, forgotten about that, and then, everything's good again, but when it comes to the will, they're left out.
That's it.
Can an estranged child then make an application for further provision against their parents' estate?
Yes. So a child is an eligible person to bring an application for further provision, and we find that a lot of our cases are estranged children who have been left out of their will by their parents.
So I find that a bit strange, I suppose, because if I'm making a will, not that I have any issues with my children, but let's say I did and I'm making a will, and because of the way I've been treated by a child or whatever, I might say, well, I'm going to leave them out or give them less or whatever. I always thought wills were about the wishes of the person who owns that estate, and then after I'm gone, then someone else is going to fight over that and not necessarily do what my wishes were. So I suppose just talking about that, as far as someone being able to make a claim when a person has already made a decision of how they want their estate to be dispersed.
So a will is a binding document, and a court will look at what is contained in the will. However, under the legislation, if a person is eligible to bring a claim and under certain circumstances, then if they're left without adequate provision, then they may have prospects in bringing a claim for further provision from the estate. But you need to meet certain elements to actually bring that claim. So it's not just easy, I haven't seen my parent in 40 years and I've totally didn't want anything to do with them, and then wanting to bring a claim. It is a lot more difficult in those circumstances.
Yeah, you'd have to show lots of evidence of why you should be receiving something.
That's
I
it.
guess, yeah. What about time limitations for an estranged child to bring a claim against an estate?
So, Steve, there are strict time limitations that apply to family provision applications. A person who wishes to apply for further provision from the estate must give notice to the executor or the administrator within 6 months from the date of death. If a person doesn't give notice within that time frame, the assets may be distributed and your rights may be severely prejudiced. Then within 9 months from the date of death, you must lodge formal court proceedings for a claim for further provision. If you don't lodge the claim within 9 months, you may lose your right of action forever. But there are certain circumstances when you can bring an application out of time, but you need to seek leave of the court to do so.
Within that time frame, how often is that 6 months from when the will has been made available? So say I'm someone who, a parent dies, and is the 6 months from the date of their death, or is it from the date that I find out that I wasn't included in the will?
This is a question that is raised quite often, because if you're estranged, typically you're not going to be given a copy of the will. So the time starts from the date of death. As a child, even if you're estranged, you are entitled to a copy of the deceased person's will. So the recommendation is to write to the executor to say, I want a copy of the will, and they should provide you with a copy of that document.
Yeah, okay. Well, that's good. That makes sense. And as you said, obviously a lot of people do ask that question. This is Law Talks, and we're speaking with Martin Mallon today, who's part of the estate litigation team at Attwood Marshall Lawyers. So how will the court view estrangement when considering a claim against an estate?
The mere fact of estrangement doesn't automatically disentitle a child from bringing a claim. The court looks at all the circumstances and all the facts. Sometimes the estrangement may be caused by one or both parties. If it's caused by both parties, so a fault on both parties, the child and the parent, then the court will look more favourably on the application from the estranged child. If an application is made by an estranged child, sometimes the provision that may be awarded from the court may be less than if it was a child that was in there, that was a loving child that had a really close relationship with the parent. The take-home message is that each case is different and depends on the circumstances. Also, there are some cases where the estrangement has been so serious that courts have dismissed a child's claim. So it is important to seek legal advice as to your prospects. So just because you are estranged doesn't mean that you can bring a claim or you will be successful. So again, you need to seek advice from a lawyer who practices in that area.
It must be difficult when the court would only hear one side of the scenario, because obviously the deceased person can't say, well, these are the reasons I did it, unless they've provided good evidence beforehand, whereas you've got another party trying to say, well, I should be entitled to something. So how does the court deal with that? And does that, I guess, mean it's important for someone making a will to be very clear in their reasons so the argument can be made after they've passed away?
So as I said, Steve, it's important to seek advice from a lawyer in respect to estate planning. So when you're doing estate planning, a lawyer can recommend to put reasons in your will as to why you've decided to leave out the estranged person. So it could be quite a lengthy statement, and that statement and your wishes and what you say, what has occurred, will be considered by a court. Also, in resisting an application brought by an estranged child, which we do, we look at all the evidence so we can get evidence from other children as to their actions and why they were estranged and why the parent didn't want them to be included in the will. And all of that evidence will be considered.
Yeah, okay. Yeah, that's helpful. So is there anything else that you as Attwood Marshall Lawyers would do, steps you would take if someone wants to make a claim?
So the steps are quite easy at Attwood Marshall Lawyers. It's a simple pick up the phone. We have a 30-minute free consultation. I'll be able to speak with someone to ascertain their prospects and likely range. Then we're able to really ascertain that quite quickly. And then we can send out some documents and let you know what the process is moving forward, which will typically be gathering all the relevant evidence, then attempting to resolve the matter with the other side, being the executor or the administrator. And if we're unable to resolve it, then we'd file formal court proceedings and resolve the matter at mediation and before trial.
A final question on this topic. Is there anything that someone who is estranged and without knowing what's in the will probably gets a sense that they're going to be left out? Is there anything that can be done apart from trying to reconcile with the parent? Is there anything that can be done beforehand to help them in their claim afterwards?
I guess the court does look at attempts by estranged children to reconcile with their parents, so that if a child tries to reconcile and the parent does not want to reconcile, well, a court will look at that. And also it's important to, if you're that estranged that you don't really have any contact with your parents or other family members, you need to make sure that when the person does pass away that you're able to meet the relevant time limitations, because if you find out 7 months later, then you may be outside the time limitations to bring an application.
All right, well, thanks very much, Martin. Really good information there, helpful to our listeners. We've been speaking with Martin Mallon today from the estate litigation team at Attwood Marshall Lawyers, and this program is Law Talks, which can be heard every Friday morning just after 9 o'clock.